Hey learners, welcome back to the channel. Today we are going to talk about one of the most important business laws in India, the Sale of Goods Act 1930. Let's quickly understand what is a contract of sale. A contract of sale is basically an agreement between a seller and a buyer. The seller agrees to transfer the ownership of goods to the buyer in return for the price, that means money. Now, this contract can be absolute, where the goods are transferred immediately, or conditional, where the goods will be transferred only when some condition is fulfilled. The sale becomes legally valid only if the money is involved. Let's quickly understand the essentials of a valid contract of sale. The following things must exist. First, there must be two different people, one seller and one buyer. Second, the item being sold must be movable goods, not land or property. Third, the ownership of the goods must transfer to the buyer. And lastly, there must be money involved as consideration. Now let's understand the difference between sale and agreement to sell. The first basis of difference is the ownership transfer. In case of sale, it is transferred to the buyer immediately at the time of sale, whereas in agreement to sell, ownership remains with the seller until a future condition is fulfilled. Talking about the type of contract, sale is an executed contract, whereas agreement to sell is an executory contract. Risk involved in the sale is to the buyer who bears the risk alone, whereas in case of agreement to sell, the risk is with the seller until it becomes a sale. The right in case of seller insolvency is on to the buyer who can claim the goods from the official receiver, whereas in case of agreement of sale, buyer cannot claim the goods even if the payment has been made. Nature of transaction in case of sale is an absolute, whereas nature in case of agreement to sell depends on the future conditions. Now let's understand the meaning and types of goods. Goods are all kinds of movable property like books, machines, clothes or stock. Money and actionable claims are not included. Let's understand the types of goods. Based on existence, there is existing goods which is owned or held by the seller when the contract is made. The further subtype is specific goods, ascertain goods, unascertain goods. Specific goods clearly are identified at the time of contract. Ascertain goods are selected from a larger group after the contract, and unascertain goods are not specifically identified. Talking about the future goods, they are yet to be manufactured or acquired by the seller. Last is contingent good, which depends on some conditions. For example, if A agrees to sell a painting only if he gets it from C. What if the goods are destroyed? There are two situations. If the goods are already destroyed before the sale and nobody knew, the contract is void. And second, if the goods gets destroyed after the agreement but before the actual sale, again the contract is void. But only if it wasn't anyone's fault, not the seller or the buyer. Let's understand the conditions and the warranty. In any sale, there are two types of promises. First, condition. That is the main point of the contract, and warranty, which is a side promise. Condition. If it is broken, the buyer can cancel the contract and get a refund. Warranty. If it is broken, the buyer can only ask for damages but cannot cancel the contract. Now let's understand the implied conditions and warranties. Some terms don't need to be written, they are automatically assumed by law. These are called implied conditions and warranty. Specifically about implied conditions, first is the seller has the right to sell the goods, must match the description. If sold by sample, the goods must match the sample, and the goods must be fit for the buyer's purpose if the buyer told the seller why he needs them. Next is the implied warranty. The buyer should get peaceful possession and the goods should be free from unknown legal claims or charges. Now let's understand the doctrine of caveat emptor. This is the Latin term which means let the buyer beware. It is the buyer's job to check the product properly before buying. For example, if you buy a shirt and it doesn't fit, it's your responsibility. So, to sum up, the Sales of Goods Act governs how goods are bought and sold in India. It explains who owns the goods, what happens if the things go wrong, and how both the buyer and seller are protected. If this video helped you, please like, share and subscribe to the channel. Also don't forget to hit the bell icon so that you never miss any updates. Thanks for watching and I'll see you in the next video.